Minister K Shanmugam.
Thank you, sir. I thank the members for speaking. Some of the points raised by members have also been addressed by Ministers Ong Ye Kung and Ishwaran. Let me try and deal with the questions that have been raised. Mr. Vikram Nair and Mr. Henry Kwek asked some questions relating to other parts of the bill that were not covered in the opening speech either by myself or Mr. Tong. These provisions are fairly self-explanatory, but let me take members briefly through these provisions. Part 6 of the bill empowers the government to direct an intermediary to prevent an inauthentic account from communicating content within Singapore and interacting with users in Singapore when the conditions are satisfied. Part 5 of the bill contains the levers relating to websites that put out falsehoods repeatedly. Such a website can be declared by the minister. A number of consequences will then follow. The website will be demonetized. Owner or operator of the website will be required to put up a notice warning users that the website has been declared, and the website cannot then be promoted using digital ad tools. Mr. Henry Kwek asked about the defense of reasonable excuse and how it will work in practice. The directions deal with the impact of falsehoods. They are not punishments. Non-compliance with the direction without reasonable excuse is, however, an offense. Clause 27 in particular sets out the factors that the court must consider when deciding if the defense is available to an intermediary. These are the state of the art at that point in time, the cost of complying with the direction, relative to the means available to the internet intermediary, and any other relevant factor. These are really all common sense factors. The bigger an intermediary is, the more it can be expected to invest and in keeping the system safe for those who use it. This also ensures that regulation does not become a barrier to entry for new entrants and thereby further cementing the domination of large incumbents. But it should not be seen as a license for non-compliance. An intermediary that does not currently have the technical features to comply with the direction does not automatically have reasonable excuse. If that were so, then intermediary can just deliberately refrain from adopting product features that are needed or developed so that it doesn't have to comply with the directions, and that will subvert the intent of the defense. That's why the bill spells out these factors, relevant factors, but the court will look at all the circumstances and decide what would be reasonable. Mr. Nair asked if this act will cover past statements. Bill will come into force hereafter with relevant subsidiary legislation on a date to be specified, as is usual. Any statement after the act, assuming it's passed, comes into force will be covered. It could also cover future statements that may be made by reference to something said in the past or statements which repeat past statements. Ms. Irene Key asked about the relationship of this bill with the Defamation Act and the Internal Security Act. Defamation Act deals in the private law sphere with damage to reputation. For example, if someone says you are corrupt, then if it's not true, you can sue to clear your name, and many people will want to. The ISA deals with threats to national security. This bill deals with falsehoods to mitigate the impact and deter those who deliberately peddle falsehoods, with a specific framework that's different from ISA. Professor Lim San San agrees with the need for the legislation but refers to a collaborative framework within the bill. There will be codes of practice for upstream regulation of tech companies. I think I can refer Prof. Lim to the Select Committee's findings on the question of regulating tech companies And it was quite unequivocal. I can give you the paragraph references: 406, 436, 476, 536. You can also look at so the select committee looked at the evidence that was presented and was quite clear that regulation was necessary. International sentiment, I mean, if you look at what the UK Digital Secretary Jeremy Wright said, and I quote, "The era of self-regulation for online companies is over. Voluntary actions from industry to tackle online harms have not been applied consistently or gone far enough." And of course, Mr. Zuckerberg himself, one day before this bill was tabled, said, and I quote, "I believe we need more serious active role for governments and regulators. I believe we need new regulation in 4 areas: harmful content, election integrity, privacy, and data portability." Mr. Teixeira articulated what the 3 NMPs accept, that the definition of falsehood and public interest in the bill. They accept that the executive must have the power to act, and they accept that trying to introduce judicial or independent oversight first risked harm in the event of an imminent threat. And I think Ms. Ong said that the independent counsel proposed by the NMPs was not meant to intervene with the decision-making process set out in the bill. As for the actual points and the NOA, I don't think you want me to repeat the points I made yesterday, so I will skip that. Then a number of comments were made on definition of falsehood. I think Mr. Singh asked, fact and comment division is not so clear, false or misleading in whole or in part is very wide. Mr. Ng talked about satire and comedy. I think Ms. Rahayu Matsam asked about efforts to educate Singaporeans. Mr. Dennis Tan talked about misleading according to whose standards. If I say something according to my own views, but what if the minister or court interprets your meaning differently? Why should I be subject to corrections or takedowns? That I find a little surprising. Let's say, Mr. Tan, you put out a statement that 3 Chinese police officers raped a Malay girl, and the police are covering it up. And then you refuse to put up a correction on the basis that, well, it's not misleading according to your standards. There have got to be objective standards in these things. And I think as a lawyer you will understand that quite easily. Or for that matter, in actual case, Mr. Nicholas Lim, that he wasn't charged because his parents were influential. I think you know who his parents were and are. And if you continue to insist that your statement that his parents were influential and that's why the police did not take action, I think there must be some objective standards. The law deals with objectivity in all these areas, so I find this statement particularly troubling. Ms. Ong, I think, gave an illustration about an NGO that has evidence from a sexual assault victim was unwilling to disclose the same details to the authorities. And Mr. Chen made a similar point as well. I think the definition of what constitutes a statement of fact I've gone through in some detail, and so have others. It's been laid down by the courts. Some, including Mr. Faisal and Associate Professor Daniel Goh, have asked, why do we use the word misleading? This reflects existing jurisprudence. The statements can be false by reason of having misled through omission. It reflects existing jurisprudence. At the end of the day, whether by omission or by express statement, the bill deals with material that is false. And I quote the Court of Appeal, which has said the test for distinguishing between comment and statement of fact is an objective one. And I quote here, whether an ordinary reasonable reader on reading the whole article would understand the words as comments or as statements of fact. The courts are equipped to apply the legal test, have regularly done so. The NMPs, for example, in the explanatory note, have said they do not propose amendments to the definition of statement of fact. The bill relies on existing case law. And before the select committee, law academics gave evidence about the law, including professors from NUS and the dean of the SMU Law School. Ms. Rahayu's question about what is education about what is covered and not covered. Yes, of course, that will continue to be done. And Mr. Louis Ng's question on satire and comedy, by definition, once you talk about fact, then it excludes. That's how the law operates. Say this is fact and falsehoods. The act applies to falsehoods. Then satire and parody is excluded. I gave some examples yesterday about how parody can be converted and put out as fact. And that's a separate scenario. I don't think you're talking about that. Yeah. Mr. Dennis Tan also asked about falsehoods in general. He said, diminution of public confidence, it's not found elsewhere in the world and will prevent bona fide criticism. I would put this point in the same league as the earlier point and would ask, what do you mean by bona fide criticism when falsehoods are generated and pushed out by bots, trolls, fake accounts, and all the other mechanisms that I spoke about yesterday? What is meant by bona fide criticism? As a lawyer, Mr. Tan will understand what is bona fide criticism. Certainly, this will not be considered by any court or anyone reasonable as bona fide criticism. So this debate in this bill, I hope it is clear that we are not dealing with bona fide criticisms. We are dealing with falsehoods. Mr. Singh had some points about Clause 4F on public confidence. Cited as an example, the recent discussion involving permits that Nas Daily obtained to hold a fan meet in Botanic Gardens. I think because his speech came immediately after Mr. Tong's speech, maybe you may not have time to look at the illustrations. And I specifically referred to it in my speech as well yesterday, precisely about this incident, and I gave various illustrations, so I will just refer Mr. Singh to that. But I would also caution generally against taking statements issued before this bill comes into force and trying to compare and take them as if they come within the rubric of this bill. I mean, those statements were issued without reference to the terms of this bill for several years. I think you shouldn't take those statements and say, therefore this comes within this bill. Different. Mr. Singh also takes issue with Clause 4 being non-exhaustive. I had set out the existing legal position in considerable detail in my opening speech, and there are many statutory provisions, including the Broadcasting Act. You've seen the definitions of public interest. This bill actually articulates the grounds of public interest with greater specificity and clarity than in earlier laws. And there are very practical reasons for keeping the list non-exhaustive. The Select Committee report states that falsehoods appear in a broad spectrum of circumstances. If you look at para 538, if we provide a closed list, then people will know precisely what the parameters are and can work around them. And we talked about foreign actors, other bad people, and the point really is public interest is the second limb. You've got to prove the falsehoods in the first place. So there are two gates. And I think once you say it's false, there's really not much argument if it impacts on public interest. And you've got to prove public interest in some way. And the courts will have the final say on the matter, if challenged. Mr. David asked for clarity on what would be considered diminution of public confidence in our institutions. Let me give you three real-life examples. I yesterday referred to the Yellow Vest movement, trying to erode trust in the police. That would be one example. Secondly, there was a case of forged letter from Sweden to Ukraine asking Sweden to ensure the dismissal of a court case in the Swedish courts, it concerning Ukrainian war crimes. Letter suggested that Sweden was prepared to do so, to make people believe that their governments were not above interfering with justice. And that is a serious diminution of public confidence and ultimately eroding trust. The third example, real example, false claim that Swedish police had said there were 50 no-go areas in Sweden filled with illegal immigrants, and these areas were too dangerous for even the police to enter. The Swedish police had said no such thing. So the effect was to suggest that the police did not have things under control, that they cannot be relied on to protect society. You can make those comments, but if you want to refer to facts, then you should get your facts right. But if you were to make a comment, oh, Swedish police do not have things under control, or Singapore police do not have things under control, you are welcome to say that. That won't be covered by the bill. But if you say, by specific reference, that these are no-go areas, and that's, it's either true or it's not true. Mr. David again spoke about advisory council, but I hear his latest remarks, and I think Ms. Lim San San also said something similar. And I think Ms. Lim's suggestion was an advisory panel to minister who makes a final order. And my point is simply this. There are many examples of how quickly these things move. Ms. NMP Ershad spoke about what happened in Myanmar. Within, I think, 24 hours, armed mobs were on the streets because of a false claim that 2 Muslims had raped a Buddhist woman, led to 2 days of violence, left people dead. In Indonesia, a rumor that a Chinese woman threw items at a mosque and stopped prayers. Within 24 hours, we had 14 Buddhist temples burnt and destroyed. It's a falsehood. Mr. Singh referred to it. The cryptocurrency's founder had died in a car crash. Within 5 hours, it wiped out $4 billion. If it was on the stock exchange, and say it relates to a bank in Singapore, and such a rumor, then there would be some public interest in going to deal with it in terms of how stock exchange and MAS deal with these issues. And these are things where immediate executive action will be necessary. It doesn't mean that the ministers will move or act without consideration. The amount of consideration depends on the time that they can take, but it has to be quick. And there has got to be, this is one of the reasons why it's different ministers, because one day it could deal with finance, one day it could deal with health, one day it could deal with SAF, another day it could deal with police. And so the domain experts, minister advised by civil servants, will have to decide quickly and open themselves up for challenge if there is a challenge, and it's all got to be done in public, quite apart from questions in Parliament. Other members, including Mr. Chris D. Souza, Mr. Cedric Fu, Mr. Gantiam Po, and Mr. Saktiandi, have mentioned the need for speed. Some members have suggested some other alternate third party to have the power to decide whether to allow falsehoods to carry on. You have a third party, the government deals with the consequences oftentimes of the falsehood. And so you then separate the power to deal with the consequences, the responsibility of dealing with the consequences from the power to stop the falsehoods in the first place. And Dr. Cha Shilu made a similar point. Really, I think the executive exercises the power and makes itself accountable to the courts and to Parliament. It's a completely defensible, open system that places no great power within the executive. And in that context, I think all the 9 Workers' Party MP speeches is remarkable for the fact that it doesn't deal head-on with the point I made, which is that the powers here are narrower than the powers that currently exist. So the Armageddon that we were threatened with, if this bill comes into law, I'm still trying to see the logical flow of that argument, but I'll come back to it. Mr. Louis Ng spoke about costs, and Mr. Dennis Tan asked about judicial review applications and cost, and Mr. Murali Pillai talked about parallel procedures providing for judicial oversight. I think quite a lot of the points I wanted to make about the speeches by the Workers' Party MPs have already been made by Mr. Pillai, I think, in a very lucid way. Mr. Ng's concerns about the cost of appeals, I already set out in some detail the process and what will happen. But when we talk about judicial review, that's quite a separate exercise. Appeals on question of fact, it should be fairly straightforward. In fact, in my view, it should be disposed of, fairly quickly. But we have provided for 2 days of free hearing, and after that, for normal fees to be paid to court, and for the court to have ultimate discretion to decide, who should pay the cost, because someone carries on and on and on for several days of argument unreasonably. That's something that the court should take into account. For example, Mr. Tan asked about costs regime for judicial review and an expedited process, and Ms. Lim makes a similar point. I think there's a very different process for appeal on truth versus falsehoods versus a judicial review. There's a whole body of administrative law principles, and that has to be dealt with judicial review in the usual way and could involve very detailed arguments. Mr. Murali asked about the risk of inconsistency in parallel tracks. I think this is not the only area of the law where that occurs, and there are procedures that the courts can adopt to resolve that. Ms. Lim, Mr. Pereira, I think they have conflated directions with criminal punishments, if I'm not wrong. Directions simply require you to put up corrections or take down the material as appropriate in an appropriate case. They are not criminal punishments. I mean, as I said yesterday, it could appear in your article that, look, there's a correction required on this because this article contains untruths or inaccuracies, and for the truth, go to such and such a website, and a link will be given. And then the reader is open to read this article, and he is open to read the other article and decide for himself. So there are no criminal consequences unless the person refuses to comply with the directions. Mr. Chen had suggested that penalties under this bill are harsh. I would say the existing penalties are comparable. As I said yesterday, the criminal provision under the bill is actually narrower because it requires both a false statement of fact and for public interest to be impacted. Engineer Dr. Lee and Mr. Melvin Yong asked for clarification on what consequences there will be for those who inadvertently forward falsehoods. If you do not know that the content is or was false, then, as I said yesterday, there is no question of criminal punishment. You may receive a correction from the platform to inform you. I mean, look at it like this. It's a falsehood that's traveled to 20,000 people. Does it make sense for the government to go and look for 20,000 people and ask them to do things? Doesn't make sense. It's not practical. The bill is primarily aimed at tech platforms. So the tech platforms to carry the corrections and push it down to the people who have received the original falsehood. And there will be questions on whether what technology allows and doesn't allow. That's the primary, in essence, focus of the bill. And in some cases, the tech platforms could be asked to take down and ensure that takedown applies across the board. It simply doesn't make sense to go and find and look for thousands of people and individually go to each one of them. It makes sense if there is one creator of falsehoods, deliberately, creating, sitting somewhere and pushing out falsehoods. That person can be dealt with. Ms. Irene, Dr. Intan, I think asked about the other legislations, how they apply, and Dr. Intan asked about academics and assurance that academics and researchers can continue to enjoy academic freedom. Mr. D'Souza asked about plans to assure well-meaning members of society that they would continue to contribute to meaningful civic discussion. And Mr. Yam said some of the constituents he has spoken with have asked if the bill will cover academic research. My colleague Minister Ong gave, I think, a comprehensive response on academia. I don't think I really have much to add. I think it's clear. So on your specific question, Mr. Yam, you asked about historians and mentioned a specific example, Operation Cold Store. The bill does not cover academic opinion. But in the same measure, as Minister Ong said, there is no carve-out for academics either for statements which are false. Let's say a historian says communists didn't intend to conduct armed insurrection in Singapore, and he relies on some documents. He interprets them in one way. That's his opinion. But supposing, say, there is no such document, and he says there is such a document, and that he manufactured his claim, then it's false. I think these situations are fairly clear. But say he refers to figures in the documents, and there are no such figures, and he just invented it. That's false. Yeah. So the courts will easily be able to deal with all of this. Or say he gave an interpretation of a document, but on oath he subsequently admits that his interpretation of the documents was misleading and that he had given an untrue characterization, an inaccurate reflection of the documents. In such a situation, of course, the academic's reliance on the underlying documents, based on his own admission, would be false. The remedy in such situations, put up a clarification. For example, that he has admitted that his statements were misleading, an untrue characterization, inaccurate reflection of the documents, and then let readers judge for themselves. Ultimately, it depends on objective interpretation, as I said earlier about the courts, but that does not preclude challenging conventional wisdom, challenging established thinking. Those are different things. Mr. Teixeira asked about the scope of the review of statements which the government has made, scope of his review of statements that government has made. I think I don't have the precise figures, but he said there were a small number of cases where the interpretations were based on facts rather than facts themselves. Look, I haven't seen them. All I can tell you is make two general points, that if the facts are accurate, and the view, I mean facts are accurate meaning you set out whatever accurately, and views are expressed based on those facts, that's not within this bill. But also, as I said just now, you must not assume all those statements in the past which have referred to a variety of things, as if this bill has been drafted with those statements or those statements that anticipated this bill. This bill is set out. Quite a few of those statements may well not come within the rubric of this bill. Right? And anyway, public interest has got to be established, and it doesn't mean that each time the government responds, automatically public interest was involved or had been involved in the past. Right? That could have been made with a number of considerations in mind, but it doesn't mean that automatically the standard for public interest set out in the bill would have been invoked. I don't know. I haven't looked at it, but these are sort of commonsensical points. And there was a question on Government Transparency and Freedom of Information Act. Ms. Irene asked about this, and Mr. Louis Ng asked about it. This is one of my favorite topics, Freedom of Information Act. I think Mr. Louis Ng said a number of countries, including China, Pakistan, Zimbabwe, they all have Freedom of Information Act. I would say we should consider, and this is a serious issue, who uses Freedom of Information Act and what has it been used for? And I'm making some serious points here. You first start looking at the requests. And when I tell you what sort of requests have been made, you can see some governance issues. Going to the UK, these are some of the requests that were made. Total amount spent on Ferrero Rocher chocolates in UK embassies. How many toilet rolls were used during Tony Blair's administration? Imagine the civil servants will have to go and calculate that across all government agencies in the 10 years that Tony Blair was Prime Minister. What kind of tea is drunk at the Ministry of Defense? What is John Prescott's weight? He was a Deputy Prime Minister. Registration numbers of all vintage lorries held by local authorities. Eligible bachelors in the police force between the ages of 35 and 49 by someone who said that she liked men in uniform. Statistics of reported sex with sheep and any other animal in Wales, if possible since records began. Now, freedom of information sounds popular, it even sounds sexy, but it basically means anyone can ask for any information, regardless of the reasons why, and without having to be responsible as to how they will use it. But the key question for us in Parliament is, when we put in Freedom of Information Act, does it improve governance or does it affect governance? If it can be shown that it improves governance, we should have it. There's no question. But does it? Let me go through the experience of the countries which have put it in. Australian Public Service, John Lloyd, Australia's Public Service Commissioner, I quote him, ever since they introduced FOIA, public servants have a culture of don't put it in writing, because if you put it in writing, it can be FOIA, due to the very pernicious freedom of information laws, and I'm quoting him. John Fraser, Australia's Secretary of the Department of Treasury, said this, freedom of information has made people extremely careful in the public service about what they put on paper, and that is sad. Open policy debate means people have got to be candid, so it's affecting open debate within government, because nobody wants to put it in paper, because if you put it in paper, it can be Freedom of Information Act, and then somebody will get it. Lord O'Donnell, former Cabinet Secretary and UK Head of Civil Service, civil servants were mentally working on Brexit plans to avoid the Freedom of Information Act. Tony Blair, 2010, he introduced Freedom of Information Act, but after stepping down, he said in 2010, Freedom of Information Act is a dangerous act because governments need to be able to debate, discuss, decide issues in confidence. So does it improve trust? And I quote you Francis Fukuyama, legislators and officials must preserve deliberative space, just as families need to protect their privacy when debating their finances or how to deal with wayward child. And they need to be able to do so without donning a straitjacket of rules specifying how they must talk to each other and to citizens. So you will get a lot of requests which are very odd, to say the least, and civil servants will have to deal with all these requests at taxpayers' expense. You know, all of this comes at a cost. And if you look at the countries and you look at who uses them, it's not the average man in the street. Of course, the average man or woman in the street uses sometimes, but mostly it actually ends up privileging and giving more advantage to those who are better organized. What do I mean? Businesses. They go for Freedom of Information Act to find out lots of information to help their business. Lawyers, lobbyists, journalists. These are the people who use the bulk or who put in the bulk of the requests. And when I give you the examples, it's immediately clear to you why. Is that the best way of improving governance? May I suggest that a better way is what we have now, this Parliament. You are all representatives who are elected by the people. Some of you are appointed, MPs, but you are here in a representative Parliament, which is sovereign. You can ask for any information that you want, and we will either have to give you the information or we will have to explain to you why we cannot give it. And if you look at the questions that have been raised in this Parliament just in the last 2 sessions, February to May, we debated, since the budget debate, 2 private members' motion, 1 adjournment motion by Mr. Pritam Singh, data security, election procedures, CPF payout, racial religious harmony, regard for women, including protection, development of the Malay Muslim community, long-term care financing, mental health, bilateral relations with Malaysia, foreign policy positioning, safe use of personal mobility devices, management of stock exchange, power failures, NUS, name it, anything that is happening out there, we are discussing them here, month by month. And you look at the number of questions. And if you can't have time, you don't have enough time for the orals, you convert it to written, it has to be answered. And again, if it's not answered, there's got to be a good reason. Questions have been raised about Mr. Pong, right? Commissions of inquiry have been, committees of inquiry have been held. Government has been questioned on the findings. It's held accountable. It's provided information. Now, if your residents have questions, or anybody else has questions, they can approach the MPs. They can approach the NMPs. Representative democracy means, at your level, you go through those questions, and if somebody comes and asks you, I want to know who are all the eligible women in SAF, I don't think representative democracy means you will come here and ask that question. And if you did, I doubt very much if you will remain an MP for very long after that. So there is a certain responsibility on you to mediate the questions that your residents ask, and then come here and ask sensible questions. Ask questions that matter for governance. Ask questions that matter for society at large, and ignore the frivolous questions, and indeed explain to your resident why those questions ought not to be asked. That makes a lot of sense. Rather than an act and legislation which has tied up, I mean, let's not talk theory, let's talk reality. I've given you examples in UK and from the head of civil service and very senior people in Australia about how civil servants have started behaving, how discussions within government have been tied up, and second, the kind of requests that are being made. I mean, can you imagine any member here asking about how many toilet rolls Ministry of Home Affairs may have used up? Of what public interest is that? Why should it take up Parliament's time? Why should it take up my civil servant's time? And if you did ask me, I will ask you to explain why you're asking it. So let's have some faith in representative democracy. We have the institutions, and we are using them well. We don't need to run after a new institution just because UK and Australia and China and Pakistan and Zimbabwe have them. Do they help in better governance? Then there were questions about, what if government itself spreads falsehoods? POFMA is here to deal with a serious problem, right? Everyone accepts it's a serious problem. So the question of whether there should be POFMA should be dealt with by reference to whether It is a serious issue that needs to be dealt with. The Select Committee says it's a serious issue. I haven't heard any speech that says it is not a serious issue. Do we have a bill? I think there is very little disagreement that there should be legislation. There is some argument about how that legislation ought to be. I'll come to that. But, then to say, oh, well, what about, other aspects? What about government? Is not really an answer. And the second point I make is what's the extent of government spreading falsehoods? And what has been the damage to society so far in the context of all the evidence that I laid out to you yesterday to the House about how falsehoods have been damaging society after society, country after country around the world. And assuming government puts out a falsehood, are there no remedies? I just talked about representative democracy. Can members here ask questions, expose? Can you ask for an explanation? Will there have to be an explanation? And if there is no credible explanation, what happens to the minister or ministry that put out that falsehood? That is what debate in Parliament means. That is what questions in Parliament means. That is what an open Parliament means. You deal with the government in Parliament. Well, some. I'm reminded by Senior Minister Teo that if you mislead Parliament, you will have to resign. There are serious processes available to pull up, haul up anyone who misleads Parliament, MP or Minister. And certainly on this side of the House, anyone who misleads Parliament will be made to resign. Now let me move on to some things that Mr. Lau has said. I think it's all equally important to see what he did not say. We face a serious problem. The report sets out the problem and it made recommendations. The government and Parliament have spent the last 18 months considering the problem. The Green Paper was in early January. Mr. Lau, I think, first, does not disagree that this is a serious problem. Two, I set out how the powers in the bill are narrower and there is more judicial oversight. I did not hear him disagree with that either. Nevertheless, he says the government will amass more powers under the bill. I will say, how so? It's directly contrary to what I've said and contrary to what he seems to accept, that the powers under the bill are narrower. He knows also that the current powers are quite broad. In fact, he said today, government can shut down Facebook. So he knows the current powers are very broad. He's also suggested making an order under the bill is like chopping off a head first and then reporting to the emperor. So typical of Mr. Lau, it's very colorful, but in this case, quite inaccurate. Let me explain. There is an original article. A correction is carried. The article stays in full. It could still be there. The head on the shoulders continues to be there. Even the hands are there. They are not cut off. And the hands can be on the computer to continue to type. And they can complain in public. And the person can go to court. And the minister will have to defend himself in court. So nothing has been chopped off. Even take down, the same process, even if there is a takedown. And of course, proportionality has to be shown as to why it's a takedown as opposed to corrections. The true analogy is this. It's like shining a torchlight, a floodlight on falsehoods. The minister is given the torchlight to shine. The person who is upset can decide to go to court, and that is, nobody's head is chopped off, nobody's hands are chopped off. it's shining a torchlight. What is the problem when we ask for transparency? I mean, it's one of the key tenets of Workers' Party. Isn't this transparency? You put up an article, government says this is not correct, you carry your correction, let your readers judge. What's the problem? More transparency, the better. And I would say a first world parliament should deal with the evidence and facts. So, if the bill is narrower and there is greater judicial oversight, the crucial question that has been sidestepped by every single one of the Workers' Party MPs is, how does it then create a greater chilling effect? How does it create more fear? Why? It's an elephant in the room that nobody has answered. 2 days of rhetoric. Mr. Law says this bill is going to have a chilling effect, and he makes a passing reference to a coffee shop. I don't think he meant it in this context. He said speech is no longer confined to coffee shops. That immediately reminded me of another speech by Mr. Lau. Mr. Lau is senior to me. I have a great deal of respect for him, in particular his political skills. He's been in the House almost as long as me, and perhaps we both immediately think in terms of coffee shops, which is of course a key node of local community and talk. So I think it will be useful to look at what he had said previously. I think you will remember 3 years ago the debate on the AOJP in this House. Mr. Lau said, this bill covers, referring to that bill, covers talk at coffee shops, makes the government the sole decision maker of public interest. Elements are similar to the ISA, Internal Security Act, all actually completely inaccurate. He said, and I quote, "I stand by what I say based on my understanding of the effect and implication of the bill if passed. For instance, there is definition of publication, and according to Clause 2 of the bill, a person is said to have published something when he communicates even orally, or even if it is just one member of the public, so that I think it applies to people who talk, discuss at coffee shops." And then he said, "Madam, what I'm most uncomfortable with is Clause 3.4 of the bill, 3 sub-clause 4 of the bill that gives the government the right to make statements and allows the government to become the sole interpreter and decision maker of what constitutes public interest. And this, I smell a similar element in the Internal Security Act." My response at that time, I said, this is a strange case. The Minister for Law, who puts up the bill after extensive consultation with the courts, I kept saying ad nauseum that the law was the same as before it was common law, and it's intended to be the same on those clauses that you refer to. And Mr. Lau disagreed with me. He said the law is different in respect of the clauses that you referred to, but was unable to explain how, why the bill changed the law, as Mr. Lau claimed. There were other clauses where, there was a change, and I explained in that long debate what the changes were and where it was the same. Likewise, in this bill, I have explained why the bill is narrower. No response. And as I said during the AOJPA, so how does a person sitting in a coffee shop in Hougang saying that something is wrong in the courts, how does that statement impact on either the judge or the witnesses or the proceedings? I mean, it's common sense. And you're trying to frighten people unnecessarily, saying that people in coffee shops now can't talk after the AOJPA was passed, and ISA, and they cannot sit there and have their coffee and talk about court cases. I said that's completely inaccurate. It's been 3 years since then. Coffee shops, I think, have grown louder since then. I don't think it has prevented talk. So after all that talk of chill and fear, I can tell you coffee shops in Yishun don't even think of the AOJPA. And I'm sure it's the same in Hougang and Aljunied and everywhere else in Singapore. Quite vibrant. And we want it to be so. So what Mr. Lau says about this bill amassing power isn't quite right. And Mr. Lau must know that. Just as he would have known that what he said about the AOJPA actually was not accurate. So what's the purpose of saying this? Because people listening to Mr. Lau might be misled. Let's move on to PGP and MGP. He said if one says government introduced the PGP and MGP to buy votes, that may be covered by the bill. Or to say that older Singaporeans are unable to accept a non-Chinese prime minister could be covered and can be used selectively by the government to target statements by the government's opponents. I say to Mr. Lau, come on, you must know, everybody here knows, none of these are covered by the bill. So let's have a debate that deals with, the terms of the bill. Let's not try and get people misled by using examples which have nothing to do with the bill. These are all comments, even under the Telecoms Act, which was in existence all this while. But there is one statement which Mr. Lau made, which is inaccurate and seriously inaccurate. He said on POHA that, and I quote, when POHA was passed in Parliament, the original purpose was only to protect individuals. But a few years ago, the government then tried to include government agencies as one of the groups protected by the Act. That is, on its face, not correct, and it's most unfair, and really should not have been made without basis. Mr. Lau is not a lawyer, so maybe bear with me. POHA has got primarily provisions on harassment, people getting harassed. Now, Mr. Lau, sit back and think about it. How can the government be harassed in the context of POHA? How is it possible for the government to be harassed? And the government has never claimed that it can be harassed, and nor has it brought a single action on the basis of us being harassed. And if we had tried it, we would have been laughed out of court. And there was a subsequent exchange between Law Ministry and Workers' Party where we said harassment provisions cannot apply to the government. But POHA, the bill, the Act, also contains Section 15, which doesn't have anything to do with harassment. It's got to do with statements and refers to statements and persons. And Mr. Singh asked me, does this bill apply to corporates? And I said, the Interpretation Act will apply. So Interpretation Act has got to apply, and depending on the context, it can apply to corporates or it may not apply to corporates. Obviously, when it comes to harassment, it cannot apply to corporates or cannot apply to government. But when it comes to statements, our view was that it can apply to the government. So harassment stalking would be sections 3 to 7 of POHA as it existed. And section 15, the government believed applied to the government, but not any of the other provisions. And the government has never sought to rely on any of the other provisions. But on section 15, the Court of Appeal, 2 judges thought that it didn't cover the government. The Chief Justice thought that it did, and the government accepted that view. It's public, it's transparent, this is rule of law. We intended and we believed, but if the court disagrees with us, we just accept it. That's that. But we have never suggested or tried to rely on any of the harassment provisions. Nor can we. It'll be absurd for us to try and rely on the harassment provisions. And then on taking people to court, Mr. Lau, Mr. Singh say, ministers can make decisions, but how often will people take ministers to court? The first point, I said orders are, as a matter of looking at the framework, likely to be made primarily against tech companies. They certainly can challenge the government. Second point, there is a very serious logical fallacy at the heart of this point. And what is that? The point that both of you make is that people don't want to go to court. But what you are proposing will require people to go to court in every single case because you want the government to sue them. So each time the government wants to do something, somebody has to be sued. So whether or not the person wants to go to court, people, they put out a falsehood. Maybe they didn't, really, after getting the notice, they just want to accept it. They really don't want the fuss of having to go to court. But you will require them to be sued and brought to court every single time. That's the difference between your proposal and the government's proposal. The government's proposal, we intervene, we ask for clarifications. In some cases, we ask for takedown. The person who is on the other end will decide, am I going to challenge? And he knows he's got 2 days free in court. He knows that on issue of falsehoods, he doesn't even need a lawyer. So it's very low cost, and he's got to decide. If he wants to challenge, he can challenge. He doesn't want to challenge, he doesn't have to challenge. Which is better for the citizen, do you think? So how does your proposal make sense? If your true objection is, well, people are reluctant to go to court, then you should be supporting the government's position. Leave it to the people who want to go to court. And we are talking theory here. I told you yesterday, a large number of these people would not be found. Quite a few might be overseas. They might be foreign state actors. They might be people working with foreign state actors. There are a variety of people. So it's more sensible what we are proposing. Let me share something with Mr. Lau, which will explain what we are really doing. Something that Mr. Lee Kuan Yew said a very long time ago. He was making a speech in 1963 in the days when Barisan was active. And I think the opponents were shouting, disrupting when he was speaking, but they did so while remaining in the dark. And they wanted to disrupt and engage in rowdyism, but did not themselves want to be seen. Mr. Speaker, with your permission, or Mr. Deputy Speaker, with your permission, can I show the video, please?
Yeah, please proceed.
But my last word of exhortation is, we have so much at stake. We have gone so far to secure the country. I say rally around and keep these evil forces. You see, they are so ashamed of themselves, they have switched the light off. Look at that. They are cowards, that's what they are. Cowards. They switched the lights off. Look at that. Are these men who are going to lead you to peace and prosperity, or to ruination and perdition? Look at that. God knows what they're doing in the dark.
Why am I showing this? What happened then, what Mr. Lee said, is very relevant here and was in many ways an inspiration for the central thinking. When people say things which are false and hide, what is the best remedy? What's the best remedy? You shine a powerful light, the light of truth, to show up the falsehoods. The lies will be shown up. People then can decide for themselves what is true and what is false. Why is the Workers' Party against that? Isn't that a good thing to have? Surely you don't want these people who put out falsehoods to hide and mislead others. So you want to shine a powerful light. That power already exists, and broader powers exist now. I explained why we are putting this bill. It's primarily to shine light on the various falsehoods that circulate so that people can understand the truth, so that the infrastructure of fact would be powerful, so that democracy itself is protected. Let me move to a different point. Mr. Singh, I thank him for his clarifications on recommendation 12 and where they stand, and I think that's got to be read together with Mr. Pereira's clarifications. In essence, as I read the speeches, the main point of difference with the government appears to be that we agree it's a problem, we agree it is serious, we agree legislation is necessary. In fact, I don't even think there is much disagreement on the provisions. But in terms of sequence, let the court decide first instead of the minister. Whereas the government's position is ministers decide, subject to an appeal which will be quick. What the government has proposed achieves the objective, subjects the government to oversight, strikes the right balance, and in fact is a narrowing of the powers from what they are today. If you applied the Workers' Party's proposal of the courts first, you cannot be sure that you can act speedily. You have to bring a person to court every single time, and that's even without considering other issues. I said foreign agents, who do you sue? How long will it take to find the originator? How do you serve? Supposing you have rules which deal with parties and surveys and ex parte and inter partes hearing, and when you look for an originator and when you don't, it gets very complex. Are you sure that it can be done within a matter of hours? No real explanation from the Workers' Party on an important point. In both approaches, the court is involved. It's not as if the court is ousted in one approach. In the government's approach, you get certainty of speed. The respondent can decide if he wants to go to court. And in your proposal, the respondent has no choice. It can become a very complicated exercise, taking time. Even if we resource the courts in such a way that there is a judge on standby all the time, and these issues are not academic. So how is your proposal better than what the government has proposed? Associate Professor Goh made the point about fact and opinion. He said ministers make the decision but not accustomed to applying the jurisprudence. Will they all come and consult me? So how are they going to act? Ministers make their decisions, ministries make their decisions based on the law and as may be advised by in-house counsel, which there are in some ministries, and by AGC where necessary. And it all depends on the speed with which they have to act. And they have to weigh the importance of acting immediately, the amount of advice they need. They will be advised by their civil servants. And if they get it wrong, they get overruled by the court. So what is the issue? Dr. Goh gave two examples, CPF and Mr. Lim, Nicholas Lim. He said the corrections have helped. He asserted it. Does he know for a fact that the corrections have helped completely cure the original falsehoods? Does he know how many people continue to believe the falsehoods without knowledge of the clarifications? I showed how falsehoods sink in. The Select Committee report sets that out. My speech yesterday set it out. The people who believe in the falsehoods exist in different universes from people who read the clarifications. If everyone was like you, Associate Professor Goh, we wouldn't need a lot of the laws we have in Singapore. We would have no problems. But unfortunately, there are people, well-meaning people, highly educated people, who don't keep up with current affairs to the level that you do. And they read what comes to them. You can't blame them. People lead busy lives. They read what they get. And I explained yesterday, the Select Committee report goes in some considerable detail, heuristic tendencies, shortcuts, depends on who you get it from, how authentic the source looks, and nowadays things can be made to look very authentic. It looks as if it's from CNN, Washington Post. I gave you examples where New York Times and Washington Post were themselves misled and published some fake stories as real. And Associate Professor Go didn't explain what's the problem with carrying the clarifications. What's the problem? Helps transparency. Rather than putting in terms of Armageddon. Clause 4F he referred to. I gave a lot of examples yesterday. 4F, you said, is very wide. But in the first place, you've got to show that it was a falsehood. And if it's a falsehood, 4F is a second gate. Why do you want to protect falsehoods? What do you stand to gain by protecting falsehoods? You expressed a lot of concern that, well, pushing down this may not be useful. Leave that to the judgment of the people who want to push it down. And you may not agree with it philosophically, but that's not a point of principle. Point of principle is there is a falsehood. If it needs to be clarified, if we believe it's necessary, then the next question is proportionality and the courts if necessary. We're not seeking to force down orthodoxy. I think we are debating at two different levels. No one is talking about forcing orthodoxies. We are talking about whether Nicholas Slim's father was influential. That's not a question of orthodoxy. It's a question of fact. You bring in arguments of public health. How do they apply? I repeat myself. Is it true? Is it false? Is it an opinion? Dr. Go also suggested there is no need for speed. I suggest he reads the Select Committee report. It may not look urgent, but if it sinks in, then it's difficult to dislodge. So even when it doesn't look urgent, you know the virality of falsehoods, they spread, you need to intervene quickly to break the virality. Because the people who read the falsehoods may not necessarily read the corrections or the clarifications. We have seen this happen over and over again. It's a well-known saying, and I quote, "A lie can travel halfway around the world while the truth is still putting on its shoes." That is the difference between truth and falsehoods. That's why you need to intervene quickly. SMS Edwin Tong spoke yesterday about the different universes that saw the truths and falsehoods in the Macron campaign. The Select Committee report is full of that. All the Workers' Party MPs pivot in their speech very quickly. First of all, they don't deal with the point that the bill is narrower in powers. Secondly, they don't deal with the fact that there's greater judicial oversight. They pivot very quickly to the broad points on free speech. And that, with respect, overlooks completely the point that we are talking about is falsehoods, turbocharged by bots, trolls, fake accounts. So, unfortunately, this debate, for all the rhetoric, there has been no engagement on the key issues, on why there should be free speech in this area. What speech are you protecting? Why are these things entitled to free speech? The real point is not these speeches about the importance of free speech, which no one can argue about, but whether we should act immediately to stop the flow of falsehoods and then be subject to court, or whether it should go to court first. That, in essence, is the only difference, and I've dealt with that earlier. It comes down after these 2 days to that one difference, really. Mr. Peng's speech, I listened and I was a little bit astonished as to whether he had read the same bill that I have. He starts with a big brother government. It gives big brother government considerable latitude to silence the common man, catches opinions, comment. Really? I mean, you've been listening to the debate. You've read the statements. This bill covers opinions and comments. I think you didn't want the bill and its provisions to interfere with the flow of the rhetoric. And you also referred to what happens during elections. My colleague, Minister Ishwaran, has pointed out, during elections, the powers are exercised by civil servants, not ministers. So that's why I said I don't know which bill you are referring to, and whether you're interested in dealing substantively with the bill we are dealing with a proper debate, or just came with a prepared speech which has no relevance to the debate. And I would suggest that the honourable member stops misquoting what I said in the CNA interview. The point is simply this. Every time you elect a government, you vest them with a whole lot of powers, including the power to declare war in extremis. How they should use their powers is not something I can vouch for. What a future government will do with their powers is not something I can vouch for. I can only say, we look at these problems, we need these legislation in place, and we have to deal with them. Just like we deal with a whole variety of issues. Just like all the other legislation that we have. Any legislation, any legislative power, any government in place for 5 years can abuse. It's a commonsensical point. The rest of the Workers' Party MP speeches repeat the points about chilling effect, conflates opinion with facts, overlooks having a correction does not necessarily mean the original post is censored, and the author can continue to post and give new viewpoints. Really, none of them bothered to deal with the current position and the important points I've made. Listening to the speeches, one phrase struck me. Mr. Pereira and his reference to industrial freezer. It's not free speech which will go into deep freeze. It strikes me that some stock phrases are kept in deep freeze by Mr. Pereira and his colleagues and brought out of the chiller once in a while and dutifully repeated. Let me explain. Let me explain what has been said previously. On AOJP, Ms. Sylvia Lim, and I quote, "Such a spectacle, if applies to this bill, will clearly have a chilling effect on public discourse. Are we not using a sledgehammer to kill an ant? It would be intimidating not just to persons on the receiving end of such investigations, but to society at large. The upshot of reducing the role of the courts and vesting draconian powers in the executive," none of that is true, by the way, "is to leave Singaporeans at the mercy of administrative discretion. We would be one step closer to being a police state." That was in 2016. Very extreme words. Since 2016, I asked members, have Singaporeans been suffering at the mercy of an administrative discretion? Are we living in a quasi-police state? What happened in 2016? AOJP largely codified existing law, introduced procedural changes which were necessary, and classified how offences were to be investigated. Professor Daniel Goh, not to be outdone, I quote, "As an ordinary person who relies on the law to protect my family, I find this proposed law casts too large and a fearful shadow on the whole of Singapore and diminishes my sense of security for my family. Reading this bill as an ordinary person sends a chill down my spine." In the last 3 years, fearful shadow over the whole of Singapore. Chill down his spine every day as he goes to NUS. Despite my clarification that before and after the bill, the law was largely the same. Mr. Singh, viewed in totality, I quote, viewed in totality, the government's approach gives it significant powers to strike fear in the heart of ordinary citizens. Mr. Dennis Tan, I quote, this bill, if passed, creates a huge shadow of fear hanging over Singaporeans who may otherwise have justified opinions on certain topical issues. Has that come to pass, Mr. Tan? You're a lawyer, you would know. I suspect not. In fact, I take a bet with you. If you go out there and talk to the man in the street and tell him AOJP, what do you think the answer will be? Simi Kong. Yeah, Kong Simi. Thank you. Mr. Pereira, not to be outdone, the result for our democracy from the passage of this bill and the attendant publicity could well be that no one who does not have $100,000 in cash to spare will dare to speak up about any issue where there is even the slightest risk or perceived risk of prosecution under this law. Earlier, I referred to Mr. Lau in his references to Internal Security Act when speaking on the AOJP as well. With the passage of the years, can be seen, all of these statements were quite unconnected with reality and quite extreme. Meanwhile, the standing of our judiciary has been going up. Lawyers, including Mr. Tan, make money partly because of the good standing of our judiciary, which was sought to be protected by that bill. Mr. Pereira also said, by reference to other countries, why are we taking a tighter approach when they are going the other way? I would say in the last 3 years, would he have preferred the trajectory of the UK versus our trajectory, whether in the courts or in general? I think there comes a time, we were a colony of the UK, but there comes a time when we have to learn to think for ourselves what is good for us and stop being colonized in our minds. Let me refer to another piece of legislation. Films Act was amended in 1988. 1988 doesn't sound right because I'm not sure Mr. Lau was in Parliament in 1988. Probably not. So I will say this, but maybe I'll have to change the date. 1998. I quote, "Bill further deprives the opposition of the right to make use of other media to reach out to the people in order to express their views on the nation, society, and the government." The PAP introduces this amendment bill just as the people of Singapore are beginning to avail themselves of some different views and comments from SCV. The government has been telling the people of Singapore that our information is open. Our people tune into foreign TV programs through SCV. However, after this bill is passed, if SCV is to telecast any program that contains unfavorable comments on the PAP which are considered to be biased, and the office in charge is accordingly found to be guilty of an offense, then is this what the PAP government mean by saying our information is open? It's been many years. Telecasts of critical programs continue unaffected. Has there been any rampant prosecution of SCV officers? I leave members to judge for themselves, and if I've gotten the dates wrong, I apologize. 1998. So you were in Parliament, Mr. Lau. So really, I think it's good for us to have the debate. Really, I was hoping yesterday, and I made this point in a very deliberate way, that there is no profit of any sort, including political profit, in trying to allow these lies to proliferate and damage our infrastructure of fact. It will damage the institutions, and frankly, no mainstream political party will benefit from this. It will damage any party that wants to consider itself mainstream and credible. everyone will be damaged. You've seen what happens in the US, you've seen what happens in the UK. The center gets hollowed out. It's the extremes that benefit. And it's not a political exercise. It is an exercise to maintain our society and the values and have a set of honest debates on what should be the way forward, honest debates on social policy, honest debates on economic policy, honest debates on how we should structure society. But it should be based on a foundation of truth, foundation of honor, and foundation where we keep out the lies. That's what this is about. This is not about the Workers' Party or the PAP, or today it is about Singapore. Mr. Deputy Speaker, sir, that ends my answers to the questions and the response speech. And with the support of the House, I beg to move.
Thank you. Mr. Pritam Singh.
I'd like to first thank the Minister for his comprehensive reply to some of the queries that were put out. I think firstly, in general, we had an exchange about the proposal that the Workers' Party put forward with the courts as the first arbiter. And I think the key issue for us was to balance, as I said in my speech, to balance the urgency of moving against an online falsehood and having a decision maker that's more acceptable than an unchecked executive. That's the position. The second point, I think Minister raised it a few times in his speech, and I believe the remark was also made by Honourable Member Mr. Seah Ken Peng about the word narrow, that the bill, POFMA, actually narrows the government's powers. Well, I can understand why that word was used, but I think very reasonable people, both inside and outside this House, may suggest that the word ought to be sharpened. If we look at Professor Goh Han's submission to the Select Committee, and this is public information, it's a matter of parliamentary record. Paragraph 27, I set out a summary of the discussion. He looks at the Telecommunications Act, the Penal Code, Sedition Act, Internal Security. Do they all cover online falsehoods? Yes, they do. Additional requirements in the case of Telecommunications Act, knowledge of falsity or fabrication, does it deal with the falsehood itself? No. Under Penal Code, knowingly spreading falsehoods that concern race and religion, does it deal with the falsehood itself? Answer is no. Internal Security Act covers only falsehoods likely to cause public alarm. Does it deal with the falsehood itself? No. But under POFMA, these matters are actually resolved because the powers are scoped. We can, again, like I said, reasonable people can have different views about which words you use, but one can also argue that under POFMA, the government's powers are actually sharpened. The other point, it's unfortunate that I did not come to this House prepared to debate the freedom of information and the points that Minister made about freedom of information, but I will try to provide some responses from...
I have no problem doing some other point in time.
For sure, but I think there are certain things which I can probably cover at least in a cursory, slightly more than a cursory manner. We look at FOI from memory. I think there are about 110 countries in the world that have some sort of a freedom of information regime. Minister is right, the regime must work for Singapore. But out of these 110 countries, about 80 of them only introduced an FOI or FOI-like legislation over the last 30 years. In some cases there have been successes, in some cases there haven't. But the FOI cannot be seen as a silver bullet. In the same way, POFMA is not a silver bullet. But it is one part of an ecosystem, one part of citizen engagement, which I submit is actually very important. And I think helps in this building of trust, not just from one government to another, but also raises the standard of conversation amongst members of the public. That's my position on it. When I was actually studying for my Juris Doctor postgraduate program in SMU, there was a requirement for students to undertake 80 years of, sorry, I beg your pardon, 80 hours, thank you, Prime Minister. That's too long. 80 hours of internship experience. So I got in touch with some friends and I did an internship at the Central Information Commission in New Delhi. This commission actually looks into right to information issues. And that experience, yes, it was only for a short 3 to 4 weeks, but it was very revealing because you had ordinary members of the public actually coming up with not ridiculous requests, but serious requests about why certain commitments made by the government were not followed through, what happened in certain cases where certain information was actually supposed to be given but wasn't given. And I saw another side of it. Granted, only 4 weeks. Minister raised some examples about Ferrero Rocher, consumption of Ferrero Rocher chocolates, toilet paper. Yes, that too. But we also have to remember that some of these requests actually uncovered issues like the expenses scandal, the MP expenses scandal in the UK. So while there is certainly a case to be made for some ridiculous requests, which of course under most Right to Information Acts can be dealt with separately and rejected.
Mr. Singh, could you please be brief with your points?
Yes,
it's pretty late already.
I'm rounding up, Deputy Speaker. The fact is that exemptions are not out of the question in freedom of information legislation. And of course, there's also the issue of questions that can be answered and cannot be answered, and the government can just put down its reasons why certain matters cannot be answered, and that's a matter of for the public. So I do apologize for having to go through this very quickly, but I thought it deserved a reply.
Mr. Shanmugam?
Yes. On the first point, Mr. Singh, I think we understand each other. You say it's sharpened. I explained why everything that we want to do under the bill can be done under existing legislation and subsidiary legislation, save for the point on territoriality. And you know, this is something that you can look at the bill and the current legislation and work out. It's not a matter of, I think, opinion, so I'll just leave it at that. On the freedom of information, I don't think we want to go into a lengthy debate. I answered because 2 MPs, maybe more than 2, raised it as fairly substantive points. I suppose the one example that you highlighted is MP expenses scandal. And the main point I made is Parliament is a representative. So I can understand why maybe they didn't raise that issue themselves, because it related to themselves. But I assume every other issue Parliament is in a position to raise. And thankfully in Singapore, you know, we don't do any special favors for MPs. So India has got a freedom of information. I think Mr. Singh would have followed the news as to how much fake news is in vogue, particularly in the current period.
Mr. Lotekian?
Mr. Deputy Speaker, first, let me thank the Minister for his effort to research into what I've said in Parliament 20 years ago. Yes, what he have quoted me, those are concerns that I have expressed in Parliament, and not only my concerns also from outside the Parliament. I have also articulated in the process of studying the provision of the bill that what possibly the government can abuse some of the provision of the bill, which I articulated, which has quoted me, and I stand by what I said. I will clarify certain points that he made, but some of the legal points my colleague would help to clarify that as well. First, he referred to my speech on the coffee shop. I talk about the coffee shop discussion on politics in relation to the advance of new media. What I'm saying is that today, political discourse does not restrict to coffee shop alone, because we can go to internet and all that, so thereby it is a progress rather than, you know, you just have to whispering around. So I don't know why he's taking issue with that, but never mind. Okay. Okay, secondly, talking about chopping off head. Okay, first of all, the minister makes that decision on whether it's falsehood, and he interprets any statement, whether it's a statement of fact or whether it's opinion, and he makes a decision to say, okay, let's take down or put out a statement of correction. That the decision is made. It's the same as chopping off head. You decide what you're going to do. And later on, of course, the person can go to the court, but the fact is that the person will have to abide by the direction of the minister first. So that is why in Chinese you say 先斩後奏. So you chop off the head, you decide what you do, you take action, and you have to act. And subsequently, yes, you're going to appeal. That's what I mean by chopping off head. Okay, thirdly, he's taking issue with me about, I saying about ISA. Okay, my view about this POTMA before this House, and compare with ISA, basically I see some fundamental in it. In ISA, the executive, the minister, basically decides what is security, what is national interest, and then say, okay, you should be locked up, detention without trial, without going through the court. Similarly, you can also appeal to the court. So the executive decides what action to be taken, and action is effected. Okay, under POTMA, similarly, the minister decides, looking at the circumstances, decide what is in the public interest, what is statement, and decide, okay, this is the action to be taken. Without needing to go to court. So to me, there are some fundamental similarity here. And the important thing is, okay, the POTMA deals with freedom of expression, because people say something, and you decide whether this is correct, whether it's factual, and I mean, it can be sometimes not very sure whether it's factual or not. I gave those examples. Ministers say it's opinion, it's not facts, but I'm not sure whether or not in some interpretation of saying a different way, it can be interpreted as facts, and thereby comes under falsehood. So these are something which we are not very clear. Of course, the minister said, I assure this House and there will be subsidiary legislation, but the question is, there's a grey area which we are worrying about. Okay, I think that's all.
Mr. Shanmugam?
Shortly, on coffee shop in new media, I wasn't taking any issue. I said your reference to coffee shop triggered in my memory a previous reference to coffee shop. Secondly, I don't really want to debate the ISA, but it's fundamentally different, and you can't go to court on the ISA. And third, on facts, I accept in good faith that Mr. Lau has some lack of clarity on what are facts and opinions, but then he has got to rely on the law and what the courts have said. So I think we can leave it at that. Thank you.
Associate Professor Walter Teixeira.
Thank you, Deputy Speaker. Minister, in the analysis of government actions against misinformation over the past few years, the point is I found that sometimes ministries were imprecise in their language. They would label, for example, differences of opinion as false. So what I'm suggesting is, would the minister consider working with whole of government to ensure that once the act is in place, ministries don't label differences of opinion as false, because then I think it has real meaning, and if you call it false, the public will expect you should be using the act against it, and if it's not at that level, maybe just call it a misrepresentation or what you wish instead.
Two things, Dr. Teixeira, I thought you were my friend. I really don't want more work. Enough as it is. The second point is you can have false opinions, So it's facts, opinions. Your opinions could be wrong, your opinions could be false, but that's not covered by the bill. But I have no doubt that any minister who wants to exercise his powers under this bill, when it becomes an act, if Parliament agrees, will have to be very careful because while I haven't gone into it in great detail, it's primarily something that might be used against tech companies and platforms, right? It doesn't make sense to use it against individuals. You think they won't challenge? Now, and so when the challenge comes, the minister will have to justify. And it's going to be something that ministers will have to think carefully about, take proper advice, and act only when it is really something that can stand by on. And that's why we haven't sought to, as I said yesterday, over-egg the pudding in terms of trying to define fact and what's not fact. We've relied on existing jurisprudence and leave it to the courts if necessary. Thank you.
Okay, I think I'll allow 3 more. Ms. Sylvia Lim.
Thank you, Mr. Deputy Speaker. First of all, Minister, you referred to what I and some others have said in the 2016 debate on the Ministry of Justice Protection Bill. And of course, I don't want to belabor the House with that debate, which is over. All right, but yes, but the fact is that those concerns that we had about how the code or the codifying the law has changed the common law by making contempt arrestable offence, bringing the police in, giving the minister an immunity. I think those points have been made, and I leave the public to judge what was said in that debate. So now, 2 specific points on today's debate. First of all, I think the minister earlier referred to what Mr. Lau had mentioned regarding the court case where the government tried to use POHA. Okay, so the circumstances, if I remember it, were the government tried to apply under POHA against a falsehood rather than for harassment. And I wonder if the minister could confirm that actually what the Court of Appeal said in its decision was that it examined what was said during the second reading of the bill, and Justice of Appeal Andrew Pang, if I'm not wrong, said that if the government had intended to use POHA for any relief, it should have been made clear during the second reading of the bill. And looking at what was recorded in the Hansard, the minister, in fact, had only referred to scenarios involving vulnerable victims. So the Court of Appeal came to the conclusion that looking at the intention that was expressed during the second reading in the Hansard, the government was not a proper person to apply because that was not the intention that was articulated in Parliament, which of course raises concerns about the effect of Hansard today for future actions of the government. And finally, if I may ask him to clarify one point, he mentioned in his roundup that during an appeal under POFMA, proportionality would have to be shown. I believe he did say something like this. So I'd like him to clarify that, because looking at the grounds of appeal, it doesn't look as if the High Court can look into proportionality. So is it actually under judicial review and not at the appeal?
Thanks for raising. The third point is easily answered. Proportionality relates to the kind of remedies that might be directed, like takedown or corrections, and it will be judicial review. Appeal is just on a question of fact or falsehood, and it's a straight appeal. So the court can look and substitute its view for that of the minister. That's what I meant by straight appeal. So proportionality is more the traditional exercise of government powers, and that will be judicial review. So thank you for asking for that clarification. Now, the other point that Ms. Lim made in terms of the Section 15, now I haven't looked at the Court of Appeal judgment recently or the Hansard, but based on memory, what I had said is in Parliament, the word persons in POHA must be interpreted in accordance with the Interpretation Act. So, and that's, I think, on the record, and that's what we stand by. If you go to the Interpretation Act, it sets out how persons are defined. So the Court of Appeal had to look at the context of the Act and look at who it applied to, and it took a different interpretation from what I had thought was correct, or what we had intended. But that's the court, and we are bound by the court. They did go through, they answered, and they thought that, Interpretation Act, they applied the Interpretation Act, but they looked at it and they said persons applying it here doesn't include corporate entities. So, okay, that's their view, but it's not as if we misled Parliament. We said Interpretation Act. It's got to be decided in accordance with the Interpretation Act, and they decided according to the Interpretation Act, except that they took a different view from us, and we stick by that. But that is only for Section 15. For the rest of POHA, there is no question that the government can or could have relied upon. As I said, it's absurd to suggest that the government could be harassed. It's not even, legally, it doesn't make any sense. So, if I could say that, I note your points on the Contempt Act.
Okay, last two interventions, Mr. Leon Pereira and Mr. Peng Ling Huat.
Thank the Honourable Law Minister for his comments. Just three brief clarifications. Firstly, I'd just like to ask the Honourable Minister to comment on the argument I made in my speech about circularity. So I think it's been said that when ministers make decisions, Part 3, Part 4 directives, they will be held to account by the electorate. They are accountable to Parliament. I did make the argument that actually by using a Part 4 directive to stop the circulation of potentially embarrassing information, the presence of a chilling effect on free expression, which I think we've talked about, the fact that efforts at investigative journalism will be cowed due to the lack of a public interest defense embedded in the bill. As a result of that, potentially embarrassing information may not come to circulation. That may, in fact, partly insulate the minister from electoral accountability and may even affect the composition of the parliament that is meant to hold the minister accountable. So I just wanted to ask for minister's comment on that. That's the first one. Second one is very simple. I'd like to ask the minister, what recourse would a victim of government-originated fake news have? And here I'm not talking about defamation action that could be taken against individual ministers. I'm talking about fake news that may originate from a ministry, from a government agency. I know the minister said that this doesn't happen very much as a question of scale. It could happen. It may happen more in the future. What recourse would a victim of such a government fake news have? POHA is apparently not a recourse. Defamation may not be a recourse. That's the second one. And the third one, the last one, the minister mentioned that, compared to some of the existing remedies, the penalties and the powers are actually a scoping down. And I think the Clause 45 of Telecommunications Act and Broadcasting Act were mentioned. Clause 45 of Telecommunications Act, very briefly, let me read it. Any person who transmits or causes to be transmitted a message which he knows to be false or fabricated shall be guilty of an offence and shall be liable on conviction, etc., etc. Now, there are two senses in which actually the definition of that is widened in POFMA, because POFMA allows for a misleading statement to be deemed false, meaning a collection of true statements that are misleading could be deemed false. Telecommunication Act says just fabricated or false. Also, POFMA says that if you have reason to believe that something is false. Telecommunications Act just says that he knows to be false. You must have knowledge, not reason to believe. So that's one point. Broadcasting Act, and I refer to Professor Goh Yihan's submission, does not apply to non-licensees. It does not apply to websites run by individuals, persons communicating via closed platform groups like WhatsApp, Telegram, etc. So in this regard, vis-a-vis the criminal penalties against individuals, which is in Section 7 of POFMA, POFMA would appear to widen powers and penalties insofar as that is concerned vis-a-vis Telecommunications Act and Broadcasting Act. So just like the Minister to comment on that. Thank you.
The first point on falsehoods and public interest. that an investigative journalist is prevented from publishing something that is embarrassing. I think I would say this. It could be embarrassing, it may not be embarrassing. All those are subsidiary factors. The primary factors, as far as the bill is concerned, is it's got to be false. And it's got to be in public interest. It could additionally be embarrassing, but that's an irrelevant consideration. Your point, I think, really, if I understand it, is it may not be false and it may not be public interest, but because it is embarrassing, a minister tries to stop it. I think that's the point you really make. Let's follow that example through. So a journalist is stopped. Now, a journalist can go to court and say, why am I being stopped? What is false? Because the minister's direction has got to set out what is false. And on the face of it, you can tell whether it's credible or not credible. And if on the face of it, it's not false, you think the journalist will keep quiet? An investigative journalist, he will go to court. I've said in 9 days you can be in court. And the minister will suffer greater embarrassment. You know why? Because not only did he try to suppress something embarrassing, but now he would be shown to have used and abused his powers and overruled by a court. So double blow. It's far worse for a minister to do that. It's very serious. Not many ministers in many countries will survive that kind of action. If a minister had tried to suppress and the court says this was neither in public interest nor was it false, I think not many ministers will survive that. Particularly if it comes out that the purpose of it was for an extraneous purpose. And judicial review is available as well. Okay, so that's the first answer. That's why I keep emphasizing the argument doesn't seem to have engaged because Mr. Pereira, you and your colleagues talk about it as if the ministers decide and that's the end of the matter. But I keep emphasizing there is a sword hanging over with the courts, and we get it wrong, we'll be publicly embarrassed. And we have deliberately made the test lower, as in it's an appeal rather than a judicial review. So the ministers put their personal reputations at stake every single time a decision is made. It's a very high onus. Second, what recourse does one have if the government is the originator of fake news? I dealt with it fairly extensively in my round-off speech. I'm not going to repeat it again, sir. Third, the penalties. Mr. Pereira said, well, compared with Section 45 of the Telecoms Act, it's actually broader, the definition, because it's misleading. Here, the bill, it's both misleading and false. I explained it just now, misleading, but it must come back to being false. And the second point is, I consider it to be narrower because the intention, you've got two things to prove in terms of intention, not just the misleading falsehood part, but also that public interest. In the Telecoms Act, the knowledge of harm to public interest is not necessary. So there are two mens rea requirements under the bill, as opposed to one mens rea requirement under the Telecoms Act. Now, you then said, well, you know, Broadcasting Act, non-licensees, closed platform groups, and all that's not covered. I think you missed my speech. I explained it in some careful detail yesterday, how the current Broadcasting Act can, through the class licensing scheme and through subsidy legislation, be made to apply to all. And I repeat, one amendment to the legislation in Parliament would be necessary to bring us to the same position that we are under the bill, and that one amendment is on territoriality, to extend it to people outside. And I don't think anyone here has a problem with that amendment. So when I say this, when I said it yesterday, I said it advisedly. But in order to explain it to members, I also then went into some detail as to how it could have been done. So if you want, I'll send you a copy of my speech as to how the Broadcasting Act could have been with subsidiary legislation and some other, the class licensing and so on, could have, we apply to all of these people while remaining much broader in scope, and while the judicial review or the judicial oversight is more restricted. So if this government, what it really wanted was just to, amass powers, why do we put up a legislation for debate that gives the courts greater oversight? Ask yourself that. If we had come to Parliament and said we now want to extend the Broadcasting Act to extraterritoriality, how much debate do you think there would have been? And then did subsidiary legislation. You could ask us questions and we'll explain this is the act and we are doing subsidiary legislation to extend. Why are we reducing our powers in that sense and saying the courts should have greater oversight precisely for the points that some of you made? It's not just this government, it's the future governments. It's a system, it's an institution. So we want to set in place more judicial oversight as these powers get exercised. But that doesn't mean the powers are being expanded. Powers are actually being narrowed. Mr. Singh says sharper, but they're narrowed. Okay, thank you.
Okay, last one, Mr. Peng Eng Wat.
Thank you, Deputy Speaker. Just a clarification from Minister, or would the Minister agree that under POFMA, that the incumbent party, POFMA would not be able to prevent an incumbent party from spreading falsehood to influence the outcome of an election, as in the example I gave for GE 2015? And also, I did mention about the alternate authority in my speech, so you can check the answer.
Let me try and understand this question. POFMA will not prevent the incumbent party from spreading falsehoods. Well, POFMA deals with falsehoods which are affecting institutions. So if the falsehoods affect the PAP or the Workers' Party, that doesn't come within POFMA, regardless of who spreads them. You may be POHAT, but not POFMA.
Election.
Yeah. I would suggest that I really think I've given the best clarification I can, sir. Thank you.
Okay.